Hello class, this is Demetrius Wilson and we are now on Chapter 8. This is Business Law. In Chapter 8 we're discussing contracts, the nature, classification, agreement, and consideration, all that goes into contracts. Our learning objectives for the chapter: what is a contract? What is the objective theory of contracts? What are the four basic elements necessary to a valid contract? Like, does someone have to be a sane individual? Do they have to be a certain age? What elements are necessary for an effective offer? What are some examples of non-offers? How do shrink wrap and click-on agreements differ from other contracts? You see these a lot in terms of shipping and then also computers. How have traditional laws been applied to these agreements? And what is consideration and what is required for consideration to be actually legally sufficient? So a little overview about contract law. The source of contract law: common law, which governs all contracts except when they're modified by statutory or written law, such as the UCC or the Uniform Commercial Code. The function of contracts are fundamental to business. Most people don't go into business with other companies unless they have a binding contract. Creates rights and duties between different parties, and provides stability and predictability. We know that if we sign this contract, I'm going to get 5,000 tomatoes and you're going to get $40,000. Parties: you have the promisor or the person who makes the promise, and the promisee, who the person who accepts the promise. Good faith in commercial agreements is always involved. Agreement that can be enforced in court. That's a part of a definition of a contract. If you don't have something that can be enforced in court, it's kind of tough to win and file any type of damages. Formed by two or more parties, the promisor and the promisee. So remember, you can have a personal contract with yourself, but it's not a contract that we're going to discuss in court. Failure to perform results in a breach and damages. Possibly a request for damages will be filed. Objective theory contracts: intent is interpreted by a reasonable person. So remember, a lot of these things in a court setting is what would a reasonable person think. If I came into your tax office, threw down a box of tax things and said, "I'll see you in 2 weeks," well, a reasonable person would think that I came in there and wanted you to actually do my taxes. Requirements of a valid contract: so a valid, enforceable, right? Remember, enforceable, like you actually take to court. Contract includes agreement, right? I agreed with you. Consideration, capacity, right? Are you in a mental state of mind? And legality: I can't sue you for not, sending the, 20 pounds of marijuana you were supposed to send me because that's not legal. Defense to the enforceability of a contract: so it must be genuineness of assent and also have a form. Also, as always, pictures like 1,000 words. So you have the contract formation. We'll talk about bilateral contracts: a promise for a promise; a unilateral contract, a promise for an act. You talk about different things like, I promise to paint your house and you promise to pay me, right? I promise, let's say I'm the lottery, because that's a good example. I promise that if you hit these numbers, I will pay you, out whatever the share amount of money is. You have formal contract, which requires a special form or of creation, actually something specific that you need to sign. And an informal contract requires no special form of creation. Express is actually formed by words, so we put words together to say, hey, this is what the contract will be. Implied in fact is like when I talked about putting down the actual all the documents for taxes and saying, I'll see you in 2 weeks. That's implied. So formed at least in part by the party's conduct. So my conduct says that I want my taxes done. So bilateral versus unilateral contract: so every contract has at least two parties: the offeror, the promisor; the offeree, the promisee. Bilateral contracts: the offerer and the offeree exchange promises to each other, right? So it's bilateral, it's the same thing. So they both exchange promise. I promise to do this, you promise to do that. A contract is formed when the offeree promises to perform, because it comes from the offerer first, and then the offeree has to accept. Unilateral contract: so offerer wants performance in exchange for his promise. The contract is formed when the offeree performs, right? So offerer they have performance and all free performance as well, then the contract has been fulfilled. And contests and lotteries are examples of unilateral contracts. I already gave that example. A revocation of offers for unilateral contracts. So the modern view is that the offer is irrevocable once the all free substantially perform. So once they perform, then it's no way to break the contract. Formal contracts, they require a special form or method to be enforceable. So for example, under seal. Informal, all other contracts involved. Express versus implied contracts. So express terms of a contract are set forth in writing or orally. Implied, in fact, is based on your conduct, like I said, about setting a shoebox full of documents down an HR block and saying, I'll see you in 2 weeks. The plaintiff furnished service or product, plaintiff expects to be compensated, and the defendant had a chance to reject and did not. And I want you to check out this case, and you'll see that it's close related to your homework assignment. Case 8.1, Urahan Construction and Design Inc. versus Hopkins. I also want you to definitely check that out and read that case. Contract performance, executed versus executory. So executed, fully performed by both sides. So I promise to do this, you promise to do that, and we both, fulfilled our promise. Or I promise to do this, and you had an act to perform, but we both fulfilled the sides that we were on. And executory is at least one of the parties has not performed. So maybe both of us didn't perform, maybe just I didn't perform, maybe you didn't perform, but in such an instance, somebody did not perform. Great picture again, a valid contract, so a contract that has the necessary contractual elements, agreement, consideration, legal capacity of the parties, and legal purpose. So from that valid contract, you have an enforceable contract. Valid contract that can be enforced because there are no legal defenses against it, right? It's fully legal. Avoidable contract is the party has the option of avoiding or enforcing contractual obligation. An unenforceable contract, a contract exists, but it cannot be enforced because of a legal defense, right? So legal defense, takes precedent, that won't work. A void contract means basically no contract at all. No contract exists, or there's a contract without legal obligation. Contract enforceability, and that's the big thing, can you enforce it in court and be paid? Valid contract has 4 elements: agreement, consideration, legal purposes, and the parties have to have legal capacity. An avoidable contract, a valid contract that is legally defective and can be avoided or rescinded by one of the parties, right? Say, you know what, I don't like this. The terms and rates of this, it's a usury. I want out, and it's easy for me to void. And a void contract is no contract at all because it's already voided. There's nothing they can do from there. Quasi contracts, you'll see a lot of stories about this, and give the example that they always say, hey, if somebody falls and they're in trouble and the doctor comes and fixes them up because he just have to be a doctor walking down the road, they create a quasi contract because the person should receive something for what they did because that's within their profession, but it wasn't something that they had to do. Fictional, created by a court to avoid unjust enrichment. You fix me up as a doctor as if I were going to Kaiser, but it just happened to be I just fell out on the street in front of you. Limitations on quasi-contractual recovery, of course, that needs to be put in place so that people just don't say, hey, we're going to do all quasi-contracts. When an actual contract already exists, quasi-contract cannot be used, right? So actual contract supersedes that. Agreement requirements of the offer. So an agreement consists of a valid offer and acceptance. So I have to offer something to you, and you have to accept it. I can't force you or put you under duress to accept it. An offer is the offerer's promise to perform. The offerer says, hey, I'm going to give this to you, and I will perform. I get the contract, I will perform by painting your house. An offer requires serious objective intention, right? So you have to have an objective intention. I'm going to skip past case 8.2, Lucy versus Simmer. I want you to look it up, though. An offer requires serious intention. So expressions of opinions are not offers. Everybody's got an opinion these days. Statements of future intent are not offers. Preliminary negotiations are not offers. Advertisements, catalog, and circulars are not offers. Auctions are not offers. An agreement to agree are not offers. So, told you everything that offer is not. An offer requires definitiveness. right? So reasonably definite terms so that a court can determine whether a breach has occurred and given any appropriate remedy, right? So it has to be, definite to get to that point. Communication of the offerer and the offeree, always important to communicate. Then we have termination of offer by act of the parties. So revocation of the offer is possible if communicated to the offeree before the offer is accepted. Exception, irrevocable offers, so you can't revoke them based on detrimental reliance or promissory estoppel, cannot be revoked. Like somebody's relying on, what you're doing for life support, and then you say, I want to go do something else, that's something in which they would step in and say they have detrimental reliance. Option contracts require consideration. You can check out case 8.3, T.W. Nickerson, Inc. versus Fleet National Bank. Termination offer by act of parties, so rejection of the offer by the offeree. So I offer it to you, I'm the offerer, you receive the offer as offeree, and then you reject my offer. Effective only when actually received by the offerer or its agent. A counter offer by the offeree. So you remember, people say, hey, this is what I think, and then other people say this is what I think. So it's a counter offer. It's not shutting anything off the table. But you do have rejection. We all have to deal with that. Get the Heisman every once in a while. Rejection of original offer and simultaneous making new offer with different material terms. So offerer can accept. You have the mirror image rule. So the rule at common law, material terms must be identical or it will be rejected as well. Lapse of time. Offer automatically terminates by law based on the term specified in the offer itself. So, there's certain things that say, hey, you have 30 days or hey, you have up until April 15th, and this is what's going to happen. Destruction of subject matter. So offer automatically terminates if subject matter destroyed before offer is accepted. And death or incompetence of either party, unless the offer is irrevocable, should just stay away from that one. And supervening illegality of proposed contract, right? So remember we talked about certain things being illegal. If it's illegal, then you can't enforce a contract. So the statute or court decision making the offer illegal automatically terminates it. So right off the bat, the illegality of that is first and foremost because you can't hold me binding for something that's illegal. Acceptance, so the voluntary act by the offeree that shows assent to terms or original offer of the actual original offer. You have the mirror image rule that we discussed earlier. Offeree must unequivocally accept the offer. Additional terms may be considered a counter offer. So you offer something like get a job offer, and then you say, hey, I like the job offer, everything's good except for I want these 3 things added. So silence as acceptance, right? So you get certain things that say if you click here, then or right here, then you object or you reject it. Otherwise, we're going to move you forward. Communication of acceptance. So authorized means of communication is either express or implied in form or offer. So U.S. mail, fax, email. Not too many people use fax anymore. You probably take out fax and put in text. The mailbox rule, which is interesting. Offeree accepts offer when the acceptance is dispatched to the offerer in the form it was received. So if you send something to me in the mail and says you'll get this great credit card rate and I put it in the mailbox, it doesn't matter that it hasn't reached you. Once I put it in the mailbox and it's dispatched, then the contract is binding. So the offer in the form that it was received unless offer requires a different method. And that's only if it requires a different method. There are, of course, exceptions. So acceptance is not properly dispatched. Offer stipulates not accepted until received. Offeree rejects, then accepts. First communication that reads, so it's kind of like the first in law. First communication received determines whether the contract is formed or not. You also have agreement and e-contracts. We talked about that, and shrink wrap agreements. So online offers should include the following. So remedies for buyers, statute of limitations, what constitutes buyer's acceptance, method of payment, seller's refund and return policy, disclaimers of liability, how seller will use buyer's information in terms of their privacy. So these all should be going on, and they should be included in the online offer. So provisions to include dispute settlement provisions. You have your choice of law, choice of form. eBay uses online dispute resolution. You might use online, or you might be a company that uses in-person alternative dispute resolution, such as negotiation, mediation, and arbitration. Displaying the offer via hyperlink. And how will the offer be accepted? Amazon.com has a checkout, right? So put these things in your cart, then you check out. You have the I accept button to click and go from there. Dispute settlement provisions. You see here, if you can see that, and I'm sure you guys, spend a lot of money online. You have these things and they say, oh, am I a robot? And that's, security functions and everything like that. But, you also have the things that, more simpler terms or simplified terms that you write your name, your address, your phone number, your credit card number. And a lot of times people don't think about what happens with that information after. Is there anything protecting you? But, you should always think about that as well. Click on agreement so the buyer checks out or clicks on I accept button on the seller's website or when their software is installed. The shrink wrap agreement, right? If you ever received something in the mail, contract terms are inside the box. Partly opening the box agrees to the terms by keeping the merchandise. And the limits, when was actual contract formed, before or after the terms communicated to the buyer. So it's like, we'll just slide this in here, but it wasn't in there before. E-signatures, technologies, asymmetric crypto system, cyber notary, just different ways to get you to actually sign in, do it on the iPad with your finger or with a traditional mouse, with your laptop or desktop. State law governing e-signatures. There's a Uniform Electronic Transactions Act of 1999. I want you guys to check that one out. Federal law e-sign 2000, which is just the following year, gives e-signatures and e-documents legal force. 90% of the time, you're going to Judge Judy and see people say, hey, I have everything on my phone here. Uniform Electronic Transactions Act. So purpose is to remove barriers to forming electronic commerce, right? So get those barriers out of the way. E-signature is an electronic sound, symbol, or process associated with a record and adopted by a person with intent to sign the record. The UETA, or if you just look at the top, the Uniform Electronic TA Transactions Act applies only to e-records and e-signatures relating to a transaction. The UETA and e-sign. So e-sign explicitly refers to UETA. Provides that e-sign is preempted by state passing of UETA. But state law must conform to minimum e-sign procedures, right? Because some people are saying, hey, just, ballpark at home. But other people are saying you need a checks and balances there. Consideration is a value given in return for a promise. So I promise to go to the game, but you have to take into consideration what are you missing on the other end. Elements, so something of a legally sufficient value given in exchange for a promise. And that is a bargain for exchange between actual parties. Adequacy of consideration. Courts generally do not look for how much consideration is given. They just look for the fact that is consideration actually given. Contracts that lack consideration, so pre-existing duty, a promise to do what one has already legally obliged to do is not consideration. Unforeseen difficulties, could be a tornado, it could be anything. And rescission and new contract. Past consideration, a promise made in return for actions or events that have already taken place are unenforceable. And we talked about that. If it's something that's illegal or even if it's unenforceable and we just didn't know the rules and regulations correctly, still got to get it out of there. Illusory promises. So if the terms of performance are so uncertain that if the promiser has not legally promised anything, the promise is illusory. It's very loose in terms of the definitive nature of it. Option to cancel the actual clauses. So settlement of claims. So accord and satisfaction. So the debtor and the creditor agree on a lesser amount, right? So once you agree, you can't come back and ask for more. You can, but it's not the right thing to do. And you won't have the court on your side. Release. One of the parties forfeits the right to pursue legal claim versus against the other, right? So I say, okay, you know what, we're good now. You gave me $10,000. I'm not going to pursue any type of claim from here. Covenant not to sue. You also have those. Like there's a covenant that we're not going to sue the other party. Parties substitute a contractual obligation for some other type of legal action. Typically, they get paid a certain amount of money, and we won't sue you because we know that when you get to the other company 2 years down the road, then you're going to take your client list with them. So promissory estoppel, along those same lines, detrimental reliance. Doctrine applies when a person relies on the promise of another to her legal detriment, right? Like, say, what if you have to go like a dialysis or something like that, the place that closes? The promisor is stopped or precluded from revoking the promise. Elements of promissory estoppel, clear and definite promise. A promisor expected promise would rely. Promise C reasonably relies by acting. The reliance with with definite and substantial detriment, right? So there's a detriment if you don't skip it. Enforcement of promise is necessary to avoid injustice. And that will be it for the chapter. So make sure that you guys, have checked out the chapter. This is also posted, meaning just the PowerPoint in the module. You have your quiz, and you also have your relative supplemental videos. So that's it. Another week down, and look forward to another great week. And as always, I want you guys all to have a good day and a great week.